right, Anderson and Erickson, 23300001508.
That matter's ready, Your Honor.
All right, and I see Miss Erickson present, and
I'm trying to make a bottle. I'm sorry.
okay. I have we were here last week, and on the 12th, and I set this over 1 week to allow some information to be filed by Miss Erickson, and told her she needed to do that by the close of business on the 12th. Nothing has been filed.
I filed things. What? Nothing's been filed. I filed things. I filed everything in there. I filed everything. How is that even possible?
And so, Your Honor, just so you're aware of what
How is that possible?
I'm guessing what she filed. We did receive a mental health evaluation from May. It was the original one that I think that we were kind of aware of, but we hadn't seen. It was not collateralized. It's just Miss Erickson, her evaluation. There's no collateral contact with the GAL or my client or anything. It was the initial one that we hadn't seen, but the GAL said at the time, this is not collateralized. We need it collateralized. It was by that same contact that I had informed Miss Erickson that he would discuss it with her if she called him back. We did also get the hair follicle back. It was negative for everything, including Suboxone, which was really kind of shocking considering Miss Erickson claims that she's on 16 milligrams of Suboxone a day. So this is the second hair follicle that was negative for Suboxone as well. I believe Miss Erickson's argument was that her body's used to it, but that's not how it works. It still shows up. Buprenorphine still shows up in your hair, unless there are those shampoos, I guess, that you can get to remove it, but they remove everything. So I am a bit concerned about that. At this point, I'd ask that either my parenting plans be entered as they are, the final orders, Miss Erickson has received those, or that if we're going to do any sort of joint schedule, that my client maintain all decision-making ability, because there's been non-compliance the entire time. We had to go through so many contempts, so many things just to get here, that I am concerned that my client will be back in court next week, the week after, the week after. It's just not going to work. Miss Langford's here as well, the GAL. I know she's been discharged, but I'd ask the court to maybe weigh in with her. We've already had a trial on this. Miss Erickson has had every opportunity to get these things collateralized. This is not her first go round. She has had 3 other cases with other children where she was asked to get collateralized mental health evaluations. She didn't in those cases either. This is, there's only so much we can do. I've tried to be incredibly helpful. I called, her counselor. I said, this is what we need. He said, fine, have her call me. I told her, call him. He can help you out. To the best of my knowledge, I've received nothing that's collateralized. This is from May of this year. It's no changes. There's nothing that the court is very specific on. We want collateralized evaluation. You have to get this updated. It's easy. I just fear that nothing will be done as it should be. It'll all approximate something without going that extra level if we don't have my client have joint or sole decision making to everything.
Madam Clerk, do you show anything filed? I don't have anything. I have things that were filed after the 12th, but those were all filed by Miss Winkles. Are you showing anything that was filed that hasn't been scanned in, or?
Odyssey's loading. Hold on.
I'm sorry, this is really odd. I filed them. I packed the baby up in the baby carrier and everything, and with my 4-year-old, we filed them.
So there's nothing new in Odyssey unless maybe she filed it this morning.
I put my whole entire life.
Or if there were issues and it got rejected, but they would have called her.
Yeah, and I filed a parenting plan too, which is odd. I did everything that I was supposed to.
Well, I want to remind you, you did everything you were supposed to 2 months later than you were supposed to, but
I know, I'm sorry. I do apologize with that.
That's part of the problem, Ms. Erickson. I understand again how difficult this process is for somebody that's not represented. But but we had a trial on this matter on the 26th of October. I gave you almost 2 months to get everything filed, and there's still absolutely nothing in the file. Absolutely nothing. And that doesn't work for me. I don't know how much more.
May I say something?
I'm talking, and when you keep interrupting me, I can't tell you how frustrating that is. I've had that conversation with you so many times. I don't interrupt you. Please don't interrupt me. Okay. I can't tell you how difficult it is understanding the difficulties of navigating this the judicial system for this case. I don't know how much more accommodating the court can be, frankly. We had a trial. I could have made a ruling that very day, and I gave you an opportunity to provide information to the court. And I'm here 2 months later, and I have nothing. And I have information that Ms. Winkles filed where she was trying to help you file this information, show you how to do that. It's email exchanges, you and back and forth that she's filed with me, telling you exactly what you need to do, and I still have nothing. So I am happy to hear from you. Please let me know why you have done nothing.
I have done everything. She has taken. Okay, I'm confused because when Scott Roberts was a part of when he was my attorney, he told me that she had taken out everything that I had put into the courts because of some kind of it was when I was at the doctor's or whatever, and supposedly something happened and we weren't supposed to be able to tell you about it, about his criminal history, about the DV. Apparently I wasn't supposed to speak of any of it. That's what Scott Roberts told me. So I had to sit there quietly about that.
Report and the parenting plan and any of that.
And then with that, Scott Roberts, I gave him everything. I seen him on here earlier and it kind of irritated me. I gave him everything to turn in. He said he turned it in. He even gave me a declaration that he wrote out, and he said he turned it in. Nothing had been turned in, and I'm just now finding that out. And I apologize. I can get everything else back in. If I can be given at least a few days, I can. I've raised my child on my own. This is just crazy to me. Erin wants to come into her life when she's 3.5 years old. That's fine. That's fine. But please don't take her from me. I've been trying to do everything I can. I did a parenting plan on my own. I did the law help one where they helped me do it, step by step. I thought that was pretty cool because I didn't know that they did that. Requesting for him to have first, third weekends of the month and every other Wednesday. I just don't understand how none of them are in there. I have turned them in. I put my entire life on that. I'm really, really baffled and kind of confused, and I don't understand any of this. It's a bad dream.
And Your Honor, if I might, even if she turned those in, they're still not compliant. As I told her, that's from May of this year. It was not collateralized. None of it's collateralized.
It was collateralized. Sorry.
I have that in my office. I can send it to the court and the parties. It was not collateralized. My client was never contacted. Miss Langford was never contacted, which is why she got the other email saying, you need to call. This is not collateralized. The court is very clear. It needs to be updated. So I'm not sure where to go. We were more than willing to try to do everything we could, but if we don't have the information, I'm not sure where to go from here. So I'd leave it in Your Honor's hands.
All right, Ms. Erickson, now you can talk. Please let people speak and then speak. Go ahead.
I'm sorry. It's just it angers me because that's not true. So when I went to Columbia Wellness to get those paperwork for you, what was it, a few weeks ago, to get my assessments, because she said they weren't assessments, they were what did she say they were? Intakes. But they clearly state assessment and they were highlighted there. The lady highlighted it for her. And then that's the reason why it took a little bit longer to get to you, because, well, it should be in there anyways, because I had to go all the way back to Columbia Wellness because the Superior Court wouldn't take it with the highlighter on it. And I didn't know that. And I was speaking with the lady and I was just basically rambling like I am now and venting because I have nobody else to vent to. about the situation. And she goes, well, that's funny because I had spoke to Mr. Anderson on the phone about this. He continuously tried to push that they are to contact him for collateral. And numerous times has he been told, and so has his attorney. My counselor even told his attorney. He told me this, that no, you are to call. The ROIs have been signed since beginning, have been signed. They've been done. All they needed to do was call. That was my fault for not telling them Columbia Wellness, because I initially at the time thought they knew it, because that's what Vashti told me was Columbia Wellness is where you get it done. I just had the baby, so I was kind of going through a lot, and then plus having threats of my baby being taken from me when I raised her on my own. Anyways, I was like, really? And then she continued to say that she actually had to send him to one of the bigger bosses, and I think his name's Chris or something like that. And Aaron continuously argued, trying to make that man say that no, we're to contact you. You're right. And he said, no, they told him that, the ROI has been done. You contact, and they've contact. I was told by that lady, and it showed in my account, supposedly that's what she said, was that they have already contacted over my assessments and stuff. So that's why I'm getting upset, because I'm extremely, extremely concerned on why people are lying so much. Like, I don't understand it. I have to be honest. And then receiving something about my child's doctor when I had already in the beginning, even Vashti knows that she goes not to child and adolescent. Like, where did that come from? Like, all this stuff that they're throwing at me when there's not supposed to be abusive litigation, that's said on my protection order. It is stated by Mary Hahn, because that's exactly what he does. And that's why I'm upset. I'm trying to calm down. I'm sorry. This is what Aaron does. It's just like, it's been one thing after another after another. I've done what I was supposed to do. I thought Scott Roberts did what he was supposed to do. He took $5,000 from us, and we worked hard for that. I don't have that. I can't afford that for another attorney to show that I'm being honest. So I'm trying to use my voice, and it's so hard to do this right now. But everything that has came out from Ms. Winkle and Mr. Anderson is just completely baffling. It's not even true. Like, I don't even understand it. Like, why? My child goes to Vancouver Clinic. She has since I gave birth to her, like.
Okay.
I'm so sorry. I'm a
couple different, thank you, Miss Erickson. I understand your frustration. The clerk asked of, she's in the courtroom. She asked of the folks in the office if there was paperwork filed. They indicated that there was paperwork filed, but they weren't, or brought in. They were not filed because they all have the wrong cause number on them. So I asked if they could be brought to me, and that's what I just received. I obviously have not reviewed them. They all have the incorrect cause number on them, the parenting plan, and it looks like some healthcare records. Is that what you received, Ms. Winkles?
It is, Your Honor. And just so you're aware, Ms. Langford has her hand up. I'm not sure if you can see that.
No, I did not see that. Ms. Langford, if you want to jump in here, by all means, go ahead and make your comment.
Yes. I'm sorry. I don't have camera ability. I'm at OHSU, where I've been pretty much every day since Thanksgiving. So I I just want to clarify some things. I've never, ever, ever received confirmation that I am on RRI for Columbia Wellness, as it states in my report. I've called, and they keep telling me the same thing, that I am not on the RRI. I've reminded Miss Erickson I need to be on there for collateral. I've not received any documentation from her since way prior to the hearing or to the trial. I still have not been contacted for any additional assessment since the one we've seen in May. Her attorney actually asked me for documentations and said he had nothing from her prior to him removing himself from the case. I gave him what I had. And I'm honestly probably equally frustrated because I've given reminders that this needs to happen, this needs to be done prior to the trial. And honestly, I have medical things with my family to deal with, and having to be dragged back and forth because we're still not getting what we need is very frustrating for me. Because I want what's best for the child, and we're not able to do that right now because we're not getting what we need. And I've not received anything from Mrs. Erickson since way prior to the actual trial that we had.
And I appreciate that, Ms. Langford. Can I just ask a follow-up question? I know that you were present at the trial that we held back in October of this year, and at that point made recommendations. Is anything about the recommendations you made at trial back in October, has anything changed, I guess?
No, I think that I would at this point I would agree with anything that you're recommending, because we're just not getting what we need to verify any information, and we're all coming back to the same courtroom for the same responses, and we can't say what's best for the child. We don't have all the information, which is what we're not getting.
All right, I appreciate that. Thank you. Okay.
May I say something? I can pull it up on my phone even. Vashti's been in there since I did it all at the same time. Why wouldn't I? I did. And I told her, I even have an email from Vashti that said, I was like, what else do I need? And she said she had everything from me. I have that in an email. I can, if I could send it over to you right now, I would. And I should have printed it out. I had a feeling to print it out, but I've been having to use my boyfriend's work because he's a mechanic and we don't have a printer in the apartment. So I've been trying to, find out ways of getting you those documents. I swear I have put all my ROIs in. That was my major deal. Like, that's a huge deal. Why wouldn't I? Like, that's my baby. I don't understand what's going on. It's like a really bad dream right now. Like, really, really, really bad. Because if I could get you everything, I'll give you all my whole profile. It shows exactly the dates when I put those ROIs in. It shows the dates and the times. And they have been in there since way before May. And I'm sorry to overtalk. That's why I needed an attorney, because I don't understand a lot of this stuff. But I need them for my boys because I'm not good at what I'm sorry, my 11-year-old's bugging me. Lexi, go sit down, please.
All right. Here's where I'm at. I kind of echo Miss Langford's comments, because I feel like even though we went through a trial, there wasn't a lot of information at the time. Mr. Anderson hadn't even, I don't believe, started any kind of weekend visitations. And I believe that we were progressing towards those with the help of Miss Rosen and her working with the child here. And but at some point I feel, I do agree with Miss Erickson that this is kind of like a bad dream, because I feel like it's the same issues repeatedly over and over again. I'm reviewing my notes and I'm reviewing the minutes from the trial, and very specifically, there was a discussion with Ms. Erickson that she needed to sign ROIs because those had not been done, and that the mental health evaluation that was done prior this year would not be appropriate because it was already at that point over 5 months old, and a new evaluation would need to be done that was collateralized. We've done nothing. So we haven't even been able to do that.
I'm gonna be I'm gonna be honest.
I'm gonna talk. So I don't know if Miss Erickson just chose to zone out when the court was making the rulings back in October.
I didn't hear
but
it.
all of the I'm muting you because you keep interrupting me. So please don't unmute unless it's your turn to speak. Very, very clearly in my notes, in the minutes, it was discussed that release of information need to be signed for all the parties so they can all be contacted for input. And it sounds like the only thing that she's done is the hair follicle, which is great. And I'm glad that that came back clean. I agree with Ms. Winkles. There is some concerns if she's claiming she's on a Suboxone program and it's not even showing that. That is a concern. That doesn't just, I get immune to a Suboxone, so it's not in my hair. That's not how that works. And she did inquire of the court whether she could file a proposed parenting plan. I said, well, you can always file a proposed parenting plan. So now I just now received that after asking the clerks to have it brought back to me, even though it's under the completely wrong cause number. So I feel like I'm extremely frustrated. I don't want to suggest at this point that Miss Erickson is a bad person, a bad mother, but I do find that there's some definite concerns about what her cooperation level would be like on any kind of parenting plan with Mr. Anderson. She claims that she wants Mr. Anderson to have visitation and to do all that. But I'm just concerned whether how that would go. Her proposed parenting plan, and Ms. Winkles, you indicated that you did have this copy, so that's why I'm referring to it. Basically says that he has to comply with treatment and that he would get the first and third weekends of the month. And that's school age and non-school age. And that's pretty much it. Your proposed parenting plan.
I meant to put Wednesdays on there. I redid another one and it deleted completely. I'm sorry.
Your proposed parenting plan basically has, it's the extreme in the other direction that
it is a phased-in approach. It's an extreme until she gets the collateral mental health, and I believe it moves to more of what Your Honor was talking about in the trial, the 50-50, but without that collateralized mental health, we had it the extreme. We had two actually filed.
We've had weekends with Dad.
Yeah, yes, he's had overnights. I believe he just had the last weekend.
I did have my overnight this last Saturday.
All right. So I do recall we just have layers. I understand Miss Erickson probably is a stressed out a single parent. I know that this is not her only child. I know there's a lot going on, and this, it's hard to prioritize things, but obviously this was a pretty major situation. I have proposed orders that Ms. Winkles has provided. What I'd like to have happen is so I'm gonna adopt the orders. There's one thing I'm gonna take out the 191 of substance abuse as it relates to Miss Erickson in the proposed parenting plan. She's a clean hair follicle. There was a history, but her claim is that she's been clean for I believe she said 6 years. So great. I'm going to take that out of the mix here. So I'm going to sign this parenting plan. So what that means, Miss Erickson, is you're going to have visitation with your child until you get that evaluation done. And then once that evaluation is done and it's collateralized, then my hope is that we'll move to a 50-50 parenting plan. But you have to get that evaluation done. It has to be collateralized. That includes Ms. Langford, Ms. Winkles, Mr. Anderson. Those people have to have that information. Once that information is provided to the court, then we'll have another hearing and adjust the parenting plan based on that. Is there a visitation that was scheduled for this weekend? Or when was it? Was there another
We were going by Charlotte. We were going by Charlotte.
Mr. Anderson, was there one for this weekend?
We were waiting for what the court hearing was going, and Charlotte wanted me to contact her after the
all Ellie knows is
propose everything.
You're hurting my child.
I hope I'm not hurting your child, ma'am, but I can't.
No, not you. I wasn't talking about you. I was because he was speaking, and I'm just saying that because he never tried until I got pregnant. So it's like I raised my baby on my own.
I'm not suggesting that you haven't put the work in, but there's concerns here that have been raised by multiple individuals.
I really didn't hear
the going on. There was
I had the baby and I was going through. Okay. I went through postpartum.
I'm done at this point. I can't argue over the top of you. I've made it known in several court dates what's been requested of you. I've tried to give you ample opportunities to get that done. I, again, am not in any way indicating that you're a bad person or a bad mother, but there are things that the court's ordered that you've basically just ignored. So we have a healthy relationship that's been established between father and child. And my hope is we'll get to a 50-50 plan, hopefully within the next few months. And this is a temporary situation that we're in. But I'm going to indicate, and there is an indication on here that once that evaluation is done and that there is, you're going to have 60 days to get that evaluation done. That doesn't mean the report has to be done in 60 days. That means it needs to be set up and
it's just minimum.
Let me rephrase that. Doesn't mean the actual evaluation, like the final report from the provider needs to be done in 60 days, but the appointment has to be done and made within 60 days.
I'll do it.
And then I'm just going to indicate in here.
Please,
I want to make sure, Ms. Winkles, and please point it out to me if it's in here already, that that this, and I don't know if you want to just set a review date or that Ms. Erickson can bring it back for reconsideration once that evaluation is done.
I believe it says that she can motion the court the moment it's done, but if I haven't put it in there, that's what I would suggest, just so we don't come back and it's still missing and it looks bad. Maybe as soon as she gets done, if it's done in a week, if it's done in 3 weeks, however long it takes, she can just stick a motion in the court and we can come back. I thought I had it at the end of the evaluation part that she has to do it in 60 days and then she can motion the court. Otherwise, it stays the same. But I've done so many parenting plans for this case. I'll be honest with you.
Right.
I can't remember.
It does say, okay, so Ms. Erickson, listen very carefully. It says, after obtaining the relevant evaluation, you can petition the court. And I'm going to say petition the court, and it says to begin weekend visitation. And here's what I'm going to do. I'm going to change the language here. So after obtaining the relevant evaluation, the mother, and this is going to basically be an agreement between Miss Erickson and Miss Winkles. The mother may.
Can I get my custody back?
Can you hold on?
Is there a way to do that?
The mother may begin weekend visitation. So evaluation's done, mother starts weekend visitation. Once the evaluation is done and all the parties have received the report, then mother may petition the court for a change in the parenting plan without an adequate cause finding. So what that means is that once we have the evaluation, everybody's seen the evaluation and been able to weigh in on the evaluation, you come back to court and then we look at the parenting plan and decide what is best moving forward. Once we have that information. Once you've done the evaluation, your weekend visitation would start. Does that make sense? Okay.
So after acknowledging, sorry.
Go ahead and ask the question, Ms. Erickson.
I'm so sorry.
Don't apologize.
After I do the collateral, I don't have money for an attorney because that man stole our money. I don't know what to do. I raised her. Like, when can I get her home? That is my baby. It's our baby. But exactly, he just now came into the picture.
I understand that, and that's why we're dealing with this. So I'm not ordering any fees, so I'm striking any judgment as requested, so I'm not imposing any fees. And okay, I'm going to mute you again here, and we need to keep our record. See here, there's a child support order in place. Ms. Winkles, I'm going to table the child support order, and after 60 days, if there's nothing, then I'm going to enter the child support order. Is that fair?
That's absolutely fine. And Your Honor, just so you're aware, we'd be okay with her filing just a motion rather than a petition. Just because I believe since she's pro se, my client he wants to be easy, but he wants to have the information is really where we're at. So we're fine with a motion rather than the full petition, because that might be a little bit more confusing for somebody who's pro se.
Okay. I don't even understand any of that right now. I'm sorry, I don't. My brain's just.
I understand that, Ms. Erickson. I would remind you, and I'm assuming, Ms. Winkles, you're going to stay on in this case.
I am, Your Honor.
Everything that Ms. Winkles has filed that about your interactions have done nothing but indicate to at least me that she's trying to help both of you through this process. So if you have a question, based on what Ms. Winkles has indicated thus far, I think she would be willing to at least try to answer those questions for you. She can't obviously represent both of you, but I've changed that to may motion the court. So that means you just say, I need to have a hearing in front of the judge about my parenting plan. And you come in and the clerk will help you and you file that. make sure it's on the right cause number, and so you know that we're under the cause number of 2331508. The child support orders I am going to set aside, so I'm not ordering any child support at this point. After 60 days, Miss Erickson, I want you to be very clear. If you don't do anything after 60 days, then this is just going to be the order. Okay.
Yeah, that's not possible. And I'm going to make sure that I'll put 3 copies in, and if anybody takes it out, then I don't know what else to say.
I'm glad to hear that. And again, once you get that process started, it sounds like Miss Winkles will help you ensure that everybody's on there, everybody's doing what they need to do.
I can't trust her. I'm sorry.
Okay, well then do it on your own, I guess.
No, I need help.
I don't know. I can't give you any legal advice. So from sitting on the bench, I can't give you legal advice. There is the Northwest Justice Project. There is Cowlitz County Legal Aid. I don't know where you reside. If you reside outside Cowlitz County, you can contact your local legal aid. But there are services available Mondays and from 12 starting mid-January, Mondays from noon to 2 p.m. There's a free attorney that's here at the courthouse that you can come and talk to. Baby? I'm sorry?
Can I bring my little baby with me?
Of course,
or is that?
Yes, no, it's not in a courtroom. It's just in the lobby in a room off the lobby of the courthouse. So if you need to bring your children, of course, you can bring your children. We'll get all of this process started. I'm gonna ask that this be filed, your information be filed with a cover sheet with a proper cause number on it, so it shows that you filed something. Okay, Miss Erickson, because I want to make sure that you obviously attempted to, but it has the wrong cause number. So I'm going to ask that they file it with the correct cause number on it.
I accidentally put the protection order cause number, and I apologize for that.
That's
I didn't
okay.
realize.
That's okay. I'm going to ask that. I don't know if.
How am I going to?
I think Miss Rosen is probably going to need to. Any counseling sessions that we can set up in the next week or two are probably appropriate. I would like the exchange to happen if at all possible. So Miss Erickson would exchange the child with Mr. Anderson on Sunday, the 24th, no later than.
There's a protection order. Can my dad do it?
6 p.m. Absolutely. Okay, so I want you to have some time on. And if you want to, if the parties agree to a later time on the 24th, that's fine. But the exchange on the 24th, so mom gets Christmas Eve, and then dad will have Christmas Day, and then we're going from there. Okay.
Your Honor, I just want to say, if she needs help with things that I can help with, I'm totally willing to help her. But I can't help with everything, obviously. But I'm willing to help where I can.
I asked you.
Well, Miss Langford's indicating that she's willing to help you. I don't know. I understand you're frustrated, and I don't understand you don't like the court's decision, but it's time we need to get this sorted out, and you need to follow through with what the court requested of you 2 months ago. So that'll be the order of the court. If it needs to be brought back, any other
get out of it.
Presentations, or if it needs to be before me, that'll have to be Fridays come the new year.
All right. Thank you, Your Honor.
Your Honor, would you be willing to call number 17 next? I'm got an appointment at 4:30.
Of course, Miss Petrie. Is that Mako and Krakenberg?
Yes, Your Honor.